Picture this. You're a few miles from home, doing maybe 5 over, and suddenly there's blue and red in your mirror. You pull over, roll down the window, and hand over your license like you've done 100 times. Then, because you're a responsible gun owner, you say the thing you were taught to say: there's a firearm in the case in your glove box. The officer nods, friendly, unbothered, and says, "Go ahead and pop that open for me." It sounds harmless. It sounds like basic safety. And that single sentence is one of the most dangerous moments you'll ever face as a gun owner, because whatever you do in the next 10 seconds decides whether you're home in 20 minutes or whether your entire vehicle just became fair game for a search. Almost everybody reaches for that case without thinking twice. By the time this video is over, you'll understand exactly why that instinct is a trap, and more importantly, you'll know the precise words to use instead, straight from actual Supreme Court decisions. Stick around, because even people who get the opening line right often get caught by one of 3 follow-up tactics officers are trained to use, and the last one trips up almost everyone. Before we dig in, understand that these encounters tend to go sideways in one of 2 ways. Either you say more than you legally had to and it becomes part of a report with your name attached, or you get defensive and things turn physical fast. I put together a full book on avoiding both outcomes called Say This, and you can grab it by scanning the code on screen or heading to Say in this book. Calm. Now let's get into the actual moment. Let's look at this from the officer's side of the glass for a second, because understanding his incentives changes everything. The instant he hears the word gun, a switch flips. His training tells him the cleanest, easiest path forward is getting you to open that container voluntarily, because voluntary means no paperwork headache, no fight in front of a judge later, no messy justification required. So when he asks you to open the case, he isn't doing you a safety favor. He's asking for access he might not be legally entitled to take on his own, and while he's asking, he's reading you. Are your hands steady? Are you talking too fast? Are you fidgeting? Does your story hold together? Every twitch becomes something he can note down and use later. The second that lid comes up, you've handed him 2 gifts in one motion: a search he never had grounds to demand, and a plausible excuse to claim you were reaching for a weapon. Neither of those benefits you in any way. Most drivers fall into one of 3 traps in this moment, and each one backfires differently. The first is what I'd call the eager helper. You want the officer to see you as one of the good guys, so you open the glove box, flip the latch, maybe even lift the firearm out to show it's no big deal. It feels polite, it feels honest. It is, without question, the worst possible move, and for 2 completely separate reasons. Now you might be thinking, isn't opening it myself just proving I have nothing to hide? Doesn't saying no make me look suspicious? I get why it feels that way, but the actual law says otherwise. In Florida versus Chimeno, decided by the Supreme Court in 1991, the justices ruled that if you give an officer general permission to search your vehicle, that permission automatically extends to closed containers that might reasonably contain what he's looking for. In plain English, the moment you crack that case open yourself, you've just consented to a full search of it, and whatever turns up is fair game in court. You haven't just shown him a gun, you've surrendered your legal position before you even knew you were negotiating one. And here's the detail most people miss from that same ruling. You're allowed to narrow or limit what you're consenting to, but only if you say so out loud. Silently popping the latch does the exact opposite of limiting anything. That's just the legal damage. The physical risk is worse. Think about what you're actually doing. Moving your hands toward a firearm, inside a glove compartment, in front of an armed stranger whose heart rate spiked the moment he heard "gun" come out of your mouth. Every use of force instructor will tell you the same thing. The most dangerous window in any traffic stop involving a weapon is the second a nervous officer watches a driver's hand travel toward it. Officers aren't trained to pause and analyze intent in real time. They're trained to react to perceived threats immediately. If his brain interprets your hand movement as reaching for the gun, there's no taking that moment back. Trying to be cooperative is genuinely how people get hurt. The second common trap is freezing up. You sense something's off, so you just stop talking, hoping quiet will protect you. It won't, and this is where even well-intentioned people get burned by a legal technicality almost nobody knows about. You might be thinking, wait, isn't staying silent exactly what protects me? Isn't that the whole point of my rights? Here's the catch. In Salinas versus Texas, decided in 2013, the Supreme Court ruled that before you've actually been arrested, simply going quiet isn't enough to invoke your rights. If you don't explicitly state that you're choosing to remain silent, prosecutors can later point to that silence in front of a jury and frame it as suspicious behavior. So freezing gives you nothing. You come across as evasive, and you don't even get the legal protection you assumed silence would provide. The lesson here isn't to clam up. It's to speak up clearly, using specific language that leaves 0 room for misinterpretation. The third trap is the over-explainer. This is the gun owner who's desperate to prove he did everything right. It's registered. Here's my carry permit. I took a safety course. Let me just grab it real quick and show you the serial number. All of it comes from a good place. All of it works against you. Every extra sentence is more raw material for him to work with. And now, once again, your hands are moving toward the weapon, this time to retrieve paperwork. What started as a routine 10-second stop has turned into an extended conversation, and extended conversations mean extended time, which is exactly what he needs. Here's the part that stings. None of that explaining actually helps you. He was never going to say, "Great, thanks for the permit, drive safe," and let it end there. He was quietly building a narrative of the entire encounter, and you just handed him the script. So why does he want all of this so badly? 2 more Supreme Court decisions explain the entire strategy. First is Schneckloth versus Bustamante from 1973. In that case, the court determined that an officer has 0 legal obligation to inform you that you're allowed to refuse a search. Read that twice. He can absolutely ask you to open the case, and he never has to mention that saying no is completely on the table. That's not an oversight in the system. That's exactly how the system is designed to work, and it relies entirely on citizens not knowing their own rights. The second is Rodriguez versus United States from 2015. Here, the court ruled that a traffic stop can only last as long as it actually takes to address the reason you were pulled over, plus the standard checks that go along with it, license, registration, that sort of thing. He can't drag the stop out fishing for something else unless he has specific, articulable suspicion that a crime is happening. So think about what your voluntary cooperation actually does for him in that moment. It solves both of his biggest obstacles simultaneously. It gives him a search he otherwise couldn't justify, and it stops the countdown clock on how long he's legally allowed to detain you. You're doing his job for him, for free, without realizing it. And that clock matters more than you think. Every second the officer spends trying to talk you into opening that case is a second closer to the legal window for the stop expiring. He knows this. That's precisely why the pressure shows up fast and wrapped in a friendly tone. He's racing against the same clock you are. He just doesn't want you to notice it's even running. There's a fear sitting underneath all of this that's worth addressing directly. You might think, if I tell him there's a gun in the car, haven't I basically confessed to something? It feels like handing him a reason to dig deeper. It isn't. Legally owning and carrying a firearm is not a crime, and the mere presence of a lawfully possessed gun is not, by itself, evidence that anything criminal is happening. An officer cannot manufacture probable cause out of legal property just because it exists in your car. What actually shifts the situation in his favor is your behavior, not the firearm itself. Reach for it, lie about it, fumble around near the console. Now you've given him something concrete to build a case on. But stay still, state your position clearly, and all he's left looking at is a law-abiding person exercising a legal right. Here's something even seasoned gun owners often don't fully grasp. There's a massive legal difference between an officer securing a weapon for safety and an officer searching a container, and the courts treat these as 2 entirely separate things. In Michigan v. Long from 1983, the Supreme Court held that an officer can search the passenger compartment of your car for weapons, but only if he can point to specific, concrete facts suggesting you're dangerous and that you could actually reach the weapon in question. A gut feeling isn't enough. The mere fact that you legally own a firearm isn't enough either. He needs articulable, specific danger, not a vague hunch. And here's the part that flips the entire power dynamic in your favor. A driver who's calm, keeps both hands visible on the wheel, clearly and voluntarily discloses a legally carried firearm and makes no move toward it is about as far from that dangerous suspect profile as a person can get. So when you keep your hands still and decline to open that container yourself, you're protecting far more than what's sitting inside it. You're removing the one thing he would need in order to justify going in there without your cooperation. The driver who opens the case hands over both the danger narrative and the search in a single motion. The driver who stays composed and states the right words hands over neither. So let's get to the actual words. Memorize them. Because when this happens in real life, adrenaline will be running the show, not your ability to think on your feet. Keep your hands visible, look at the officer, and say this: "Officer, there's a firearm in that case. I'm not going to reach for it. I don't consent to any searches. Tell me what you'd like me to do, and I'll do it." That's the entire script. Say it once, say it calmly, and then stop talking. Let's break down why every piece of that sentence is pulling its own weight. "Officer, there's a firearm in that case," is your disclosure. In roughly a dozen states, including Texas, Michigan, Louisiana, and Alaska, you're legally required to volunteer this information. In most other states, you're required to disclose it the moment you're asked. Saying it up front covers you everywhere and immediately removes the surprise factor that puts officers on edge. It's a plain statement of fact, not an admission of wrongdoing, because carrying legally isn't wrongdoing. "I'm not going to reach for it" keeps your hands exactly where they are and shuts down any danger narrative before it starts. This is Michigan versus Long in action. You're proactively eliminating every specific fact he could later use to claim you were a threat. And you're making sure that if the firearm does get secured, it happens on his terms, not because you moved toward it. I don't consent to any searches is the line Schneckloth makes absolutely essential. Since he's under no obligation to tell you that refusal is an option, you take that decision into your own hands and state it plainly. And remember what Himeno established. You can limit consent, but only through actual words. This sentence draws that boundary at 0. Unlike simply staying silent, this is an affirmative statement, which solves the exact problem Salinas exposed. Tell me what you'd like me to do, and I'll do it, is the smartest part of the whole exchange, because it keeps you fully cooperative on everything that's actually lawful, while never once granting the search itself. You'll step out of the vehicle if instructed. You'll position your hands wherever he asks. What you will not do is personally open that case. One more practical note, because your firearm won't always be tucked in a glove compartment. Maybe it's in the center console, maybe it's zipped in a bag on the passenger seat, maybe it's holstered on your hip. The wording barely changes, just swap out the location. Same disclosure, same stillness, same spoken refusal. If it's on your body and the officer decides it needs to be secured, tell him exactly where it is and let him retrieve it himself. Never reach for a holstered firearm to hand it over. That single decision is how a routine, lawful encounter can turn catastrophic in a fraction of a second. Now, the follow-up tactics, because a trained officer rarely gives up after the first attempt fails. There are 3 moves he's likely to try next, and you need a response ready for each one. The first is the soft reassurance. His tone shifts, gets gentler, and he says something like, "I just want to confirm it's unloaded," or "I just need to check it matches your permit. Go ahead and open it up." Don't. Opening it to be accommodating is still consent, and it's still your hand moving toward the gun. Your response doesn't change. There's a firearm in the case. I don't consent to any searches. If it needs to be secured, you're welcome to do that yourself. The second tactic is the guilt trip. If you've got nothing to hide, why won't you just open it? This one lands hard on decent people because it stings. But declining a search is a legal right, and the courts have made clear you can't be treated as guilty simply for exercising it. That question only has power, because he's betting you don't know about Schneckloth. Think about who that line is designed to work on. It's built for the honest person, the one who's never broken a law and can't stand the thought of appearing guilty. Someone who's actually hiding something doesn't care how it looks. You do, and that's the exact lever being pulled. Once you recognize it, it loses its grip entirely. Your answer? "Officer, it's nothing personal. I just don't consent to searches." The third tactic is escalation. "Fine, step out of the car. Or then I'll just open it myself." So if he orders you out, comply calmly and without argument. That's a lawful order the Supreme Court upheld in Pennsylvania versus Mims back in 1977. But stepping out of the vehicle is not the same as consenting to a search. So restate your position as you go. "I'm stepping out because you asked me to. I still don't consent to any searches. And if he searches anyway, do not physically resist, ever. Let it happen. Stay composed and remember every word that was said, because that documented refusal is precisely what a lawyer needs later to challenge the search in court." So here's everything wrapped into one idea. When an officer asks you to open that case, recognize what's actually being requested. That lid represents the search itself, and he needs your hands on it because his own hands might not be legally allowed to go there without your help. Keep your hands visible. Disclose the firearm. State your refusal out loud, clearly once. Then let him make his own decisions about your vehicle without any assistance from you. Stay calm, know the exact words, because a traffic stop involving a firearm isn't a casual conversation. It's the most consequential few minutes you may ever spend being evaluated by the legal system. And the person who knows precisely what to say is the one who drives away from it.